Arguments are underway in the Supreme Court regarding a major gun rights case. The High Court will determine whether or not the government can prevent domestic abusers from owning a gun.
Federal law that has been in place since 1994 prevents people under domestic violence protective orders from owning a firearm. Well, research shows that a victim or survivor of domestic violence is 5 times more likely to die when an abusive partner has access to a gun. So for more on this, I want to bring in Bernadette Meyler. She is a professor at Stanford Law School. Thanks for joining us. What have we heard from oral arguments today?
I think that the oral arguments in the court today were fairly supportive of the government's position that the statute at issue should be upheld against a broad challenge. And I think one of the interesting parts of the argument was that it really clarified, or it helped to clarify, what should be the test going forward under the Bruin decision, which was decided about a year and a half ago, and which said that Second Amendment rights should be analyzed by looking back at state statutes and state restrictions on gun rights in the 19th century. Now, the Solicitor General in the oral argument today was asked by Justice Kagan about what the test should be going forward. And she said that the court should really reiterate that it's not just state laws prohibiting Second Amendment rights or prohibiting gun ownership that should be looked at, but rather a whole host of evidence about the original meaning of the Second Amendment. And then also that in order to understand whether a right can be restricted today, that we should be looking at broader analogies from the past. So we should be looking at whether someone is particularly dangerous or not capable of responsible gun ownership in order to figure out whether their gun ownership could be restricted today, rather than at whether particularly states targeted domestic abusers in the 19th century for restrictions on gun ownership.
Mm-hmm. So how, you mentioned Justice Kagan, how did some of the other justices respond to those oral arguments?
Well, it was not that active in terms of questioning. I would say that Justices Alito and Thomas were the two most skeptical of the government's argument. And in general, they were most concerned, I think, about the fact that what was at issue is a kind of civil proceeding, so that it's not the basis for the restriction on gun ownership here wasn't a criminal conviction, but rather a civil decision and a civil restraining order. And that was one of the things that they were talking about. But I think General Priligar had a good response to one of Justice Alito's questions, which was basically about, well, how do we know that these state court proceedings are fair? And she said, well, there has to be a presumption at the Supreme Court level that states are acting in a judicially fair way, and that has always been the presumption that the Supreme Court has used.
How does due process come into play here?
So that's where due process comes into play. I think that Justices Thomas and Alito were wondering whether there's sufficient due process to determine dangerousness in these particular instances. I think that that's less of an issue in this case, where there was an individualized adjudication, than in potential future cases where there might be a categorical decision by a legislature that certain classes of individuals might be dangerous. And in this instance, the challenge is to the law as a whole, to the law that restricts domestic abusers or those who've been subject to a restraining order from possessing firearms. So in this particular case, there was an adjudication, and there's no real due process issue.
What will conservative and liberal justices focus on when they ultimately decide on this?
I think what they're really going to focus on is both elaborating the test in the Bruin case and trying to figure out how it applies. I mean, there have been hundreds and hundreds of cases decided by federal district courts and then also by circuit courts trying to apply this test. And it's been very difficult to apply because it seems to ask the courts to go back to looking at 19th century statutes and finding an analogy to any contemporary restriction. So I think that the justices will focus on trying to clarify, exactly how close the analogy has to be, whether those statutes are going to be the only things that the justices will look at, or whether there's going to be a broader meaning. I think that the other thing that some of the justices may talk about is what to do about cases like a situation of domestic violence where women couldn't vote largely in the 19th century. The statutes that they would be looking at restricting firearms ownership or weapon ownership would probably not touch on domestic violence because it wouldn't have been a prominent issue. So how do we think about those situations where the kinds of legislation is newer in nature?
Yeah.
It's dealing with groups who weren't represented before.
Yeah, that's what I was thinking, that, back then, I don't think domestic violence was kind of a carved out standalone crime. I don't even know if abusing your wife in any way was. Perhaps women were almost like possessions. So it's sort of hard to apply the standards, whatever the founding fathers were thinking of, to our modern day issues. But that is why I am not a Supreme Court justice. We'll have to figure that out. Bernadette Meyler, thank you very much.
Thank you.